All right, wonderful. Well, welcome. My name is Holly Lechniak. I'm the Outreach Director for the AARTS Center at Rush, which is the Autism Assessment, Research, Treatment, and Services team here. We are a part of Rush University Medical Center, and we are very excited to partner with Brad Dembs today. I will allow Brad to do a further introduction of himself, but Matt is a lawyer with Matt Cohen and Associates, and he'll be presenting to us all today on evaluations and eligibility for special education. As a reminder, we will be recording this presentation, and so we will have an opportunity to go back and look at it. If anybody does need to step out early today, we do encourage questions. We want to make this as interactive as possible. So if you have a question, feel free to submit it in the chat or in the Q&A. With that, I want to welcome and thank again, Brad, for joining us today and for sharing your expertise and your time. So go ahead and take it away.
Great. Thanks, Holly, and hello to everyone who's joining us. My name's Brad Dembs, as Holly said. I'm an attorney with Matt Cohen and Associates. We are a law firm based in Chicago, but serving the entire state of Illinois and beyond a little bit, focusing primarily on special education law, representing families of children with disabilities who are struggling with getting an appropriate education for their children in school. And what we're going to be talking about today is a really important topic, sort of when you're right at the start of potentially receiving special education, figuring out if your child's eligible for services and what those services and instruction should be. So if we go to the next slide, you can see that we're going to be talking about these topics today: special ed eligibility, how that's figured out and determined, and then how evaluations are used for that purpose. We'll talk a little bit about the basics of what a free appropriate public education is, and then I'll give you some information on sort of the 101 of what an IEP is, and some advocacy tips about how to ensure that you develop a great IEP that meets your kids' needs. And then we'll talk briefly about resolving disputes if you're unable to work with your school district collaboratively. So eligibility under the IDEA, and by the way, IDEA means Individuals with Disabilities Education Act. That's the main federal law that covers and guides everything that we're doing and provides for your rights and your children's rights in school related to special education. There are also state rights in Illinois and in other states that can be a bit different from each other and from the IDEA, but mostly what we're discussing is covered under the IDEA, and the state law mirrors that to a large extent. So to be eligible for special education, you must meet criteria for at least one disability category. We'll talk about what those are on the next slide, but before we do that, that's not the only thing that you need. The disability must adversely affect your educational performance, and the student must need special education interventions. So if we go on, we'll discuss what those things mean in more detail. Here are the 13 categories. We'll just take a quick look at them. Some of the most common ones that we usually deal with are autism, other health impairment, specific learning disability, but these are all categories that can come up, and we'll talk about a few of them, highlight a few of them as we go along here. So what does it mean to adversely affect educational performance? And remember, you need to have an adverse effect on educational performance to be eligible for special education. So first of all, it's important to remember, or to sort of keep in mind, that educational performance doesn't just mean academic performance. Education is academics, sure, that's a big part of it, but it's also your functional performance, behavior, social skills, coping mechanisms, and also physical abilities, occupational skills, in terms of fine motor coordination or being able to navigate the school building. These are all things that are part of the big, broad term educational performance. So if any of those areas are affected adversely by a student's disability, it may lead to a determination that you're eligible for special education. And generally, the impact should be seen in school and outside of school, but sometimes there are disabilities that have an impact that shows itself in school because that's where the skill deficit is being displayed. And also important to note that you don't have to have poor grades or low achievement test scores to have an adverse effect on educational performance. So then the question becomes, does the child need special education? Special education is a service, not a place. We highlight that at the top here because oftentimes school districts will say, oh, you need special education. We have a classroom where we provide that. That's not accurate. The question is what service is needed, not where it's provided. You have to build that in individually for the student. We'll talk about that a little more too. But special ed is broadly defined as specially designed instruction, including adapting the content, method, and mode of delivery of instruction. The child doesn't have to be educated in a special ed classroom to receive special education. So now we'll talk about a few of those common categories. Other health impairment is a chronic or acute health condition. Can be asthma, diabetes, ADHD is a really common one. And it results in limited strength, vitality, or alertness. And that includes limited alertness to educational tasks as a result of heightened alertness to environmental stimuli. So if a student has ADHD and they're distracted by things going on around them in the environment that limits their ability to pay attention to academic tasks, again, the next step is it has to adversely affect educational performance. So looking at how is the child performing in school, are their grades low? That can be one measure, but again, not the only measure. For example, another impact could be if the child is having behavioral issues because they're distracted, and that's taking them away from being able to participate in lessons in class because perhaps they're being sent out of class for being disruptive. That's an adverse effect on educational performance. Emotional disturbance, you have to meet one of the following criteria. Can be an inability to learn due to emotional factors, inability to build or maintain interpersonal relationships, inappropriate behaviors under normal circumstances, general pervasive mood of unhappiness or depression, or physical symptoms or fears. And then the next step is, if we go to the next slide, those conditions, or at least one of those conditions, must be present over a long period of time to a marked degree and must adversely affect a child's educational performance. So what a marked degree or marked degree is can be kind of tough to define. It's sort of a situation of, you know it when you see it. If a child is having emotional issues in school, could impact their ability to attend school at all, or could result in them having behavioral issues again, or potentially just emotional issues and anxiety in the school setting that can lead to eligibility under emotional disturbance. And then specific learning disability means a disorder in one of the basic psychological processes involved in understanding or using language, can impact speaking, reading, writing, spelling, math, And this is something that's typically diagnosed by a psychologist or a neuropsychologist that then you can provide outside diagnoses to your school district to let them know that you've got a child who's dealing with a learning disability. It can also be diagnosed by a school psychologist. So just a quick note about RTI, which is response to intervention. Sometimes we see school districts using RTI as a way to screen children before determining if they're eligible for special education. So providing certain interventions or somewhat specialized instruction and seeing how a child responds before they'll evaluate them for special ed. And to some extent that is okay, but RTI can't be used to delay or deny evaluating a child. So if a parent requests an evaluation, we'll talk about that in another slide. If an evaluation is requested, the school can't say, well, we need to spend X amount of time doing RTI before we evaluate. It's something that can be helpful, but it can't delay evaluations. And that's because school districts have what's called a child find mandate, or a duty to identify, locate, and evaluate all children suspected of having disabilities. And all includes all children, those who are attending public and private schools, homeless children, and even children who are advancing from grade to grade. Again, your grades can be one indicator of whether you need special education, but not the only one. Just a note that there's a comparable requirement under Section 504, which is another law that provides for educational rights for children. We mostly during this presentation will be talking about the IDEA, but Section 504 is another avenue to receive some accommodations and services. So child find is an affirmative obligation on the district. Parents don't need to request an evaluation for the district to conduct an evaluation or to initiate an evaluation being conducted. The school should recognize when a child may need special education and initiate an evaluation on their own. Anybody with knowledge of the child can make a referral for an evaluation. So if there is an outside clinician working with the family, a private psychologist or therapist or social worker, speech language pathologist, on and on, that person can make the school district aware that this child may need special education, but then an initial evaluation has to be initiated by the parent or by the district. And here's another note that the district can screen the child to decide whether to proceed with testing. And that screening is part of what we refer to when we're talking about RTI. So remember the previous slide, we said the school can do RTI, but they can't use that as a way to delay testing. Right, so here it is in the next bullet point. It's part of the process, but can't be resulting in a delay. So then if the school does decide to evaluate, they have to provide notice to the parents of the testing that they're proposing to do and the reasons for the specific testing. And that's most often done through what's called a domain meeting or a consent assessment plan, where they'll go through various domains with you, like academic performance, behavior, physical, speech language, occupational therapy, and determine what types of evaluations, if any, are needed in what categories. So this is a big point. Written and informed parent consent is required for all individual evaluations and reevaluations. The district has to make parents aware of what evaluations they're planning to do and get the parents' consent to do those evaluations. And when the school does evaluate, the idea requires that they use a variety of assessment tools and strategies, and not use any single measure or assessment to determine whether a child has disability. And that's because single tests can be misleading. The example here is, one IQ test may not be sufficient to determine if a child has an intellectual disability. That's because there are potentially flaws in various tests or biases in the testing that may affect children in different ways. So they have to use technically sound instruments that assess the relative contribution of various factors. For example, if a child is highly distractible and they're being tested for ADHD, they should use methods and strategies or tests that account for that by taking those various impacts on a child into account. So evaluations and assessments have to be non-discriminatory and provided in the language and form most likely to yield accurate information. So that's important because it requires the district to account for the child's specific needs and circumstances when they're determining what evaluations they're going to conduct. It's not a one-size-fits-all type of process. It really requires a consideration of who the child is and what their needs are. So for example, if a child is nonverbal, meaning they can't speak or talk to the evaluator, then you wouldn't want to conduct an evaluation where the child has to give answers using their voice because they can't. So any results would be invalidated. So they need to account for things like that and conduct nonverbal testing. So the timeline for completion of evaluations is very clear under the law. If a parent requests an evaluation, the school district has 14 school days to respond and seek the parent's consent. And remember, seeking consent includes providing information about what evaluations are going to be conducted. The parent request on its own doesn't automatically equal consent because of that requirement that they respond to the request by explaining what evals they're going to conduct. So then once parents consent, evaluations must be completed within 60 school days. So the evaluation is completed, eligibility determined, and an IEP meeting held, all within 60 school days. And there can be some flexibility there, particularly if there's an agreement about using an outside evaluator or if there are timing limitations at play. So an IEE, that's an independent educational evaluation. And that means that it is an evaluation conducted by someone outside of the district. The law provides that parents can request an IEE if they're dissatisfied with any district evaluation. So if your school district does an evaluation and it comes back with a result that you disagree with, says maybe that your child doesn't need special education when you believe that they do, you can request an independent evaluation at district expense. And the district has to respond within 5 days in Illinois and either agree to the evaluation or they can request a due process hearing if they feel that their evaluation was appropriate and they don't want to pay for your private evaluation. So we usually tell parents, if you have the means to, you can get an evaluation at your own expense at any time by a private evaluator. So if it's covered by insurance, or if you can afford to pay for it out of pocket, then you don't need to go through the process of requesting an independent evaluation from the district. And that may allow you to get it done quicker and without any input from the school district that could limit or affect the results of the evaluation. And a few other points to note. If you are disagreeing with a district evaluation and requesting an IEE, there arguably has to be an evaluation that the district already did that you're disagreeing with. But there are circumstances where a district may refuse to evaluate or ignore a parent's request to evaluate. In those circumstances, you may be entitled to an IEE because the district had an opportunity to do their own evaluation and failed to do so. Also, you're only entitled to one IEE at public expense in response to each district evaluation that you disagree with. So some general issues related to evaluations and just some recommendations here for you to keep in mind when you're getting evaluations done. If possible, you should talk to the evaluator before and after the evaluation. Before, to make sure that the referral questions are clear and they understand what is being evaluated, and to express any concerns you have if you have concerns about specific tests or tests you want to avoid, especially if evaluations were conducted within the previous year. You want to make sure that the evaluator is aware of what testing was done so they don't repeat specific evaluations. And you want to provide them with existing records, particularly recent IEPs or evaluations, and make sure that they'll talk to school staff as well. So this is more significant when you're talking about a private evaluation, right? Because if it's a school district person who's doing the evaluation, you still want to know what to expect and make sure they know what you are concerned about, if anything. But some of these things are likely to be built in already with a school evaluation. Some more issues, especially when placement is that issue, or when you're concerned about how much time a student is getting in one environment versus another within a school. You should consider having an evaluator do an observation in person in the school, or even a virtual observation if that's possible. If you have an independent evaluator who is doing an evaluation, they have to have the same opportunity to observe in school as the school staff would have. So if the school tries to limit or prevent a private evaluator from coming into the school, that's something that you could object to. Also, in regards to any evaluation, you want specific recommendations. That's more useful to you when advocating for what your child needs. So you don't want something that says, oh, they need special education. You want something that says how much time, in what setting, and what methodology they need. So an example of that would be if your child has a learning disability and the evaluator feels like they need a multisensory instructional program that's designed specifically to remediate learning disabilities, they should say that explicitly and say where that should be implemented. Word choice is really significant in terms of making recommendations. So the law, the IDEA says, and we'll talk about the FAPE standard in a minute, but essentially your child is not entitled to the best education, as sad as that may be. Your child is entitled to an appropriate education, meaning what is necessary for them to have an educational benefit. Not what's best, just what's needed, right? So think about it as the difference between a Cadillac and a Toyota Camry. No offense to Camrys out there. I drive one, it's a great car, but it's not a Cadillac or a Mercedes. So your child's education is entitled or required to be a Camry. a car that can drive, that can get them from place to place, but it doesn't have to have all the bells and whistles unless those are explicitly needed for your child. So that's why we want evaluators to state what's necessary, not what's best. And avoiding other language like it might be helpful, or it would be beneficial, or it should be considered. This is kind of equivocating or not firm, right? We want firm language that says this child needs this. Not maybe, definitely. So to whatever extent an evaluator can say that, that is much more helpful in making recommendations and advocating for those specific things. Just a note on rating scales. These are typically parts of evaluations that are done for behavioral or executive functioning or emotional issues. And you want to get rating scales completed by school staff and parents. So you're getting a balanced or a more broad perspective on the child's functioning in these areas in different settings. So here's the FAPE standard that we were just talking about a little bit: free, appropriate public education. The F, the P, and the E are pretty easy to understand. Free is free, no cost to the parents. Public education, that means education in your public school. The A, appropriate, is where there's a lot of gray area, and as a result, a lot of litigation and argument. So what is a free, appropriate public education? Well, Andrew F. is a United States Supreme Court case from earlier in, I was going to say this decade, but it was actually at the end of last decade. And this was a case that set a new standard for what a free, appropriate public education is. What Andrew F. said that was a change from the previous standard is that minimal benefit is not sufficient. Just making a little bit of progress is not appropriate. To determine what's appropriate, you have to have an IEP that's reasonably calculated to enable the child to make progress in light of their individual circumstances. So again, we're focusing individually on this particular child. What is needed to enable them to make progress? Schools and families need to be realistic about what's accomplishable for the child, taking their disabilities into account. But the IEP must also provide an ambitious program with challenging goals and objectives. So the aim here is for the child to be challenged to build skills and develop beyond what's easily attainable while staying within the realm of what's realistic. And that can be a hard balancing act sometimes, but what we're really trying to do is be ambitious without being overly ambitious, right? We don't want a child's IEP to just say, oh, they can increase their reading by 1 grade level, if in reality they have the ability to increase their reading level by 5 grade levels within a year, right? Because if we set the standard or the goal at 1, then we're working towards that and maybe not pushing for further progress that's possible. And to determine what's possible, this goes back to evaluations. You need good evaluations to determine what a child's current abilities are, so you can plan for what services and goals will move them towards the heights of what they're capable of. So this all gets boiled down into an individualized educational program, something that's tailored to the unique needs of the student, individualized. It should identify all the student's needs related to their disability, provide goals and objectives to address those needs, and identify what special education, related services, and accommodations are necessary to meet the child's needs. When you are setting off on this process of creating an IEP with your school district, you should think about what you're trying to accomplish. What skills are you trying to address? What's the ultimate trajectory for this student based on their disability and their needs? And what rate of growth is possible and likely for this student? And then also, just practically speaking, how much time is available, right? We're sort of talking about early stages here, but maybe you're in a situation where your child wasn't evaluated or found eligible for several years, and now you're facing the prospect of the end of their educational career coming up quicker than you'd think. So how can you get them to achieve the goals that you have for them before they graduate? These are all questions to ask going into an IEP meeting. So the most important question to ask really is there enough information available to support what the child needs or what the parents are asking for? You can't advocate for an IEP that's appropriate without knowing what the child's disabilities are, what they need, what's worked and not worked in the past, and so on and so forth. So just note that you want information that is credible. So that means information that is pretty recent by someone who is qualified to make the recommendations or provide the information that's being provided. So again, oftentimes this process starts with school district evaluations, and that's fine. If the school district identifies your child's needs and you agree with that, then you can move forward and create an IEP based on that. If you feel like an outside perspective is needed, remember you can always request an independent evaluation or provide input on your own from private clinicians or evaluators who are working with your child. But more information is always better coming into an IEP meeting. So here are all the IEP steps, just laid out for you as kind of an agenda of how a meeting typically goes. And we'll walk through these all one by one. So label, remember we talked about the 13 eligibility categories. Those are also known as labels for special education. So a label or an eligibility category should match your child's needs, and you need to be eligible under at least one of them to receive special education and related services. So having the right label can be significant. It shouldn't in the most basic sense. Once you have an eligibility, you're entitled to whatever services your child needs, regardless of that eligibility label. So a good example would be, let's say your child has an emotional disability and they require a lot of social work support because of that. Well, if they also have a speech impediment, maybe they are eligible as well under two categories, emotional disability and speech language impairment. But even if the team didn't find them eligible for a speech language impairment, they're still entitled to receive speech language services in school. So don't let the eligibility label limit the services that your child's receiving, or let the school district tell you that they can't receive services because they don't have a specific label. The label can be important though, like it says, related to placement. So if your child has a certain eligibility label, it may preclude them from being placed in a certain program, or they may need a certain eligibility label to be placed in a certain program. And that could be a private therapeutic day school. Some private therapeutic day schools are authorized to provide services to students with specific labels and not others. So that may be an important point to discuss if you are trying to end up with a certain placement. Student strengths is one of the preliminary stages of an IEP, and it's really an opportunity for you to brag about your child, and what parent wouldn't want to do that. But the purpose of this isn't just to talk about how great your kid is. It's to put into context what their strengths are so you can compare them to what their weaknesses are. And also, if it's a case where you're concerned about your school district trying to push your child out of a general education setting and you want them to be included with their general education peers, having a good, robust student strength section will be particularly helpful in highlighting why a student should have the opportunity to be included in that gen ed setting. The next section is parent concerns, and this is another opportunity for you to speak your mind and not be edited down or constricted in what you're saying by the school district. This is your chance to sort of set expectations for what you're trying to achieve and what you're concerned about. This is also a good place to include things that the district may not report elsewhere in the IEP. And all of your concerns should be discussed and addressed during the IEP process. If you want to do so ahead of time, depending on how robust or involved your concerns are, you can prepare a written statement and present it to the school district and say, these are my parent concerns, please attach them to the IEP. The school district can't tell you that the parent concerns are too lengthy or they only have a certain box that they have to fit all of the concerns into. That's not an appropriate response. They can always attach the full statement to the IEP. The PLAF, so here's another fun acronym. This field of is full of these acronyms. PLAF is present level of academic achievement and functional performance, more easily referred to as present levels. So again, academic achievement and functional performance. So what are your child's current skills and deficits in academic and non-academic areas? And you want actual data here and not just anecdotal. So not just a report from a teacher that says, oh yeah, he can read these words, but not these. You want testing that actually shows you what the child can and can't do. And if you have private testing data, you should insist that that be included as well as a part of the big picture. So the impact of disability on access to the general curriculum and functioning. What you want to do here is think about what your ultimate goals are and identify strengths and weaknesses based on that. So if you are advocating for more intensive services, if you're advocating for a change of placement to a therapeutic day school, for example, you should maximize the ways in which the child's needs can't be met in the general ed setting or in the public school setting. And on the flip side, if you're trying to increase inclusion, you should try and emphasize strengths, as we discussed, and minimize those areas of weakness. Certainly not to a point where you're not acknowledging what the weaknesses are, but providing them within the context of what is possible in the current setting. So really just keeping in mind what your goals are in how you talk about your child's needs can be helpful. So goals are really the way that we measure an IEP. There are annual goals, which are set for 1 year from the date of this IEP meeting, because IEPs take place annually, where you review progress and determine changes that should be made. By the way, IEP meetings can happen more than once a year, but they're required to take place at least annually. So your annual goals say by 1 year from this date, the child will be able to do X. And then within goals, there are also short-term objectives that are typically benchmarks building towards the annual goal. So you can see if you're making expected progress throughout the year. When you're developing goals, there's no limit on how many you can have in an IEP, but you want to think about what you're trying to achieve. Again, being strategic and being relevant. What are the most significant problems to be addressed, and make sure there are goals in those areas. And if there are things that you are concerned about, but maybe aren't as high of a priority, you don't necessarily need goals for every single small issue that your child has. But you can. Absolutely, you can have goals for everything, and you should have goals that address the areas of significant concern. The big question in terms of what's required under the law is, are the goals measurable? To be measurable, we'll talk about what a measurable goal looks like on the next slide, but just another couple of points here. Do the goals embed the placement that you want? If the district's willing to write the goals in this way, it can be a good advocacy tool. So give an instruction using a research-based program. If that's what the goal says, then that's the type of programming that has to be provided. So trying to advocate in that way, writing the goal for the program or the services that your child needs can be helpful. So I think the next slide, yeah, right. So clear, measurable baseline data that directly relates to the skill being measured in the IEP goal. That's the gold standard. That's what's required under the law. So here's an example. Good baseline data will tell you not just that the child can read 45 words per minute, but the student can read grade level text orally at 45 words per minute with 90% accuracy in 4 consecutive trials during pull-out resource minutes. So you see how much information is in that one little tidbit. You're getting details about all the conditions on how and when the student is displaying this skill. And that's important because then if you look down at the goal, the annual goal would be from 1 year from that date. Given research-based multisensory instruction, the student will independently read grade level text orally at 90 words per minute with 90% accuracy in 4 consecutive trials. So this is giving you a goal based on your baseline to make sure that you are building a goal based on what the child can currently do and what you expect them to be able to do moving forward. So then accommodations. You want accommodations to be clear, avoiding optional accommodations like as needed or at teacher discretion, because that provides just opportunities for things to be done less consistently, right? If it's at teacher discretion, well, maybe the teacher didn't notice that the child needed it at this time, and then, oh, well, that's what the IEP says. So you want it to not be wishy-washy in that way, but just say specifically when accommodations will be provided. Along the same lines, you want to avoid putting responsibility on the student. So you don't want to say that an accommodation will be provided at student request because maybe the student doesn't want to request it. Maybe they're shy or have issues with self-advocacy, or maybe they just are overwhelmed and forget to request things. You don't want that to be an impediment to the accommodations that are necessary to be provided. Excuse me. This is also a great place to build in things that the school won't list elsewhere. You can examine an example that we have here is the parent communication log. So if you're concerned about getting sufficient information about what your child's doing in school on a daily basis, if your child's nonverbal, for example, having a parent communication log can be a really helpful accommodation to allow you to be a part of the process and understand what your child's working on at school on a daily basis. So the accommodations pitfall is really something to keep in mind that may not be so intuitive. Accommodations seem great, right? These are ways to, as it says in the name, accommodate your child at school. So for example, if your child has issues writing, you can say, okay, well, don't worry about writing. We'll accommodate that by giving you a scribe or someone who can take notes for you or write your answers down on a test. But that doesn't teach a child how to build that skill, right? There's no development of a child's skill by accommodating for that. Accommodations really boost the school's performance, not the student's performance. So the way to account for that is to make sure that there are goals corresponding to those areas that are being accommodated. An example would be, if the teacher will check the assignment book for accuracy, the goal would be the student will record assignments accurately. If the student's using a word processor for essays, the goal would be the student will learn to keyboard at whatever words per minute and whatever accuracy. So use the accommodations that are necessary as another way to advocate for goals. So say, look, we're agreeing to accommodate this skill deficit. We should also have a goal to make sure that the child can develop the skill that's being accommodated. Otherwise, it's really just a Band-Aid. Services and placement. So this is usually a page in the IEP that's laid out kind of like a grid, and it will list the classroom minutes and spell out what location and subjects and type of class. So if your child is in a resource room or a self-contained classroom for a certain amount of the day, but not others, this is where that would be listed. Also related services, which are non-medical services that are necessary for the child to benefit from instruction. So that includes speech, social work, occupational and physical therapy, and any other services that are necessary to benefit from education. Those are listed on this grid as well, and list the specific amount of time and should spell out whether these are going to be pull-out services. Are you taking the child out of class to work with them? Or are you pushing into the classroom to work with them? That can be relevant depending on what kind of skills you're trying to develop. Also should indicate whether it's individual or group, and should be as narrow or specific on the time frame as possible. So saying how many minutes per week will be provided is a lot better than saying how many minutes per month, because that provides for less flexibility for the school. If you think your child needs to have consistent 30 minutes once a week of social work services, for example, then the IEP should say that. It shouldn't say 120 minutes per month, even though that would equate to the same amount of time, because then it's just open to more flexibility for the school to provide 100 minutes one week, 20 minutes another week, and nothing for 2 weeks. that gets you to 120 minutes, but it's not consistent in the way that that may be needed. And also don't allow consult minutes to be lumped with direct minutes. What that means is sometimes an IEP will list minutes that are consult, meaning they're just opportunities for the related service provider, like the physical therapist, to talk to the teacher, the special education teacher or the general education teacher, about the child's needs and what may be going on in the school, in the classroom. Those minutes shouldn't decrease from the actual minutes of direct instruction or service being provided. It can be listed separately. This is also the place to address whether a one-on-one aid is being provided and for how many minutes of the school day, and what assistive technology supports may be provided. So LRE means least restrictive environment. And what the law says about this is that a child has to be placed in the least restrictive environment that's appropriate to allow them to meet their needs. So that doesn't mean that they have to be in a general education classroom if that classroom's not appropriate to meet their needs. If they need more support or a smaller classroom setting, then it may be appropriate for them to be in a different classroom or in a different school. And that can be the least restrictive environment. It's really, again, an individualized question about what the child needs. And this determination is supposed to come after every other part, for the most part, of an IEP. And that's because placement shouldn't determine services, but the opposite. What services are necessary for the child should determine what placement they're going to be in. But sometimes it may be good to talk about placement up front if you think that's going to be a point of contention, and then you may be aware of how to advocate for what you need. They should also list in the IEP other options that were considered, what the potentially harmful effects are of different options, to essentially create a log of how the decision was made, what placement is going to be decided on for the IEP. And this process is usually driven by the special education director or other administrator who's running an IEP meeting. But if you think that other staff members at the meeting may have a different opinion, if there's a dispute about placement and it's clear that they're going with something that you disagree with for placement, then you may want to just ask everyone at the meeting, what's your opinion, right? To see if there's any lack of consensus or differing opinions that you can tease out from the IEP team. Transportation, just a note that this is a part of an IEP. It can include whatever services or accommodations are needed. So if your child needs an aid on the bus to ensure that they're safe, if they need a special harness to be able to be secured on the bus, these are all things that can be included in the IEP under transportation. ESY is extended school year. So this is special education or related services that are provided beyond the normal school year, most typically over the summer, in accordance with the child's IEP, and again, at no cost to the parents. And the goal here is maintenance of a skill, not acquisition of new skills or further development. Really, the purpose of ESY and when it's determined necessary is if there's a risk of regression, if a child doesn't have consistent ongoing services over a period of time when school's usually out of session. So again, that's typically summer, but it could also be over longer breaks like holiday breaks if that's necessary. That's something to be discussed with the IEP team. And the amount of service is usually less than during the regular school year, because again, you're not looking for progress to be made, you're looking to maintain student skills. FBA is a functional behavior assessment. And BIP or BIP is a behavior intervention plan. So this can be a part of an IEP, incorporated into the IEP. It can also be a standalone document. This is an opportunity if your child has behavior issues in school. And FBA is a type of an evaluation, functional behavior assessment, to determine why the behavior is occurring, and then to inform a behavior intervention plan, which is a strategic document that's used to try to include strategies to preempt behaviors from occurring, if you can predict when they might occur, and how they will be addressed and responded to when they do occur. And you want this to be a pretty robust and broad behavioral umbrella, describing all the characteristics that might make it difficult for the student to understand right from wrong, understand rules, hear or respond, whatever may account for why behaviors may be occurring. You should include that in the behavior plan. And this is important, as we'll see on the next slide, because of this language here was the direct result of the failure to implement the IEP. And the other piece that's not included there is whether behavior was the result of a child's disability. So this is a safeguard in the law, in the IDEA, so that when children have behavior issues that are related to their disability, they're not being punished because of their disability. Okay, so you see down near second line from the bottom where it says MDR. Here's another acronym to throw at you. That's a manifestation determination review. So when a child has behavior issues in school that may result in a change of placement, so if they're being suspended for 10 or more days or expelled from school because of behaviors that are occurring, there has to be a manifestation review meeting where the school district and the parents ask and answer two questions. First is whether the behaviors are related to the child's disability, and two is whether the behaviors occurred as a direct result of the school district's failure to implement the IEP. So having a IEP that includes a broad behavior plan provides some safeguard to ensure that if that's not followed, or if it's clear that the behaviors are related to the child's disability, the school district can't remove the child from school because of those behaviors. Just a quick note on resolving disputes, just kind of a reality check, so to speak. There are multiple avenues for you to address disputes. And disputes can be anything from refusing to find your child eligible for special ed, refusing to provide specific instruction that they need, or disciplining them despite their disability, like we just talked about. If you have a disagreement that you can't solve just by asking them to fix it or change something, if the school district refuses to do what you feel is necessary, then you could file a request for mediation or a due process hearing request, or in some circumstances, a state complaint. These are all varying levels of dispute resolution. And when you file a mediation request or a due process hearing request, a protection called stay put applies. This is important to remember in cases where the school district is proposing to change your child's placement to something you disagree with, or change the IEP in a way that you disagree with. If you file for mediation or due process within 10 days before a change takes place, that blocks them from making that change. And they have to keep the previous IEP in place while the dispute is being resolved. So you can find more information from the state's website on dispute resolution, but unfortunately, specifically filing a due process complaint without legal representation is really onerous and difficult. Parents who file complaints on their own are dramatically less successful in getting an outcome that they're looking for their child. And I don't mean that to come off as an advertisement for legal services. It's just an unfortunate reality that the process is very complicated. It's almost like a trial where you present evidence and question witnesses and have a hearing officer make a determination on what your child needs and whether what you're asking for is appropriate or not. So having an attorney is almost necessary for this process. And would you look at that? I am an attorney. It doesn't mean that you need to use me, but our office is always available to talk to you, and I'm available to just consult if you have specific questions. No charge. I'm happy to spend some time talking to you about broad questions you may have, and then if you were interested in talking to us in depth and potentially getting representation, we can talk about that as well. So our office numbers are here. My email is here. I encourage you to reach out to me at any time with questions based on what we talked about today, or anything that comes up after today that you have concerns about. And then I don't know, Holly, if we have any questions that I can address now, I'm happy to do that too.
Wonderful. Well, first, thank you so much for sharing your expertise. It's a lot to navigate through. And as you highlighted, just so many acronyms and so many pieces that are just, can be really complicated and convoluted. And so I think the way you broke it down was so helpful. We had a couple questions come through, and as part of the IEP, one of them was related to transportation. And this is something I think our Chicago families felt really intimately this last year in returning back to school from the pandemic. But do you have any sense or any guidance on any recourse or kind of pathways that families can take if districts just don't have the capacity to provide transportation, even when it is a part of the child's IEP or required in that? And I think we've seen this, and we saw this at CPS this year where they didn't have the drivers, and there wasn't, for some of our families, there just weren't options available. And so what recourse do families have in those instances?
A few things. First, it's a really tough situation to navigate, because to some extent, it's not the district's fault, right? They should be doing everything they can to make transportation available. But if there aren't drivers because of a shortage, as we've seen, there may be some sympathy or deference given to them if you were to file a complaint about that. But having said that, it is still a requirement in the law, and there are a few things that parents can do. One, if they have the means to transport themselves at the start or end of the school day, or have a family member that can do it, they could submit for transportation mileage reimbursement to be paid back by the school district for the school district's failure to provide that. If there are more dire circumstances and there's no way to get the child to school, they could request ongoing remote learning if that's appropriate, which it's not for a lot of students. And certainly we saw that remote learning was detrimental for lots of students. So that leads us to sort of the worst possible circumstances, which is there's no way to get your kid to school and they can't learn at home. They're sort of stuck. What you can do then is try and keep track of what your child's current abilities are, or what the school had reported their skills were based on their goals at the time when transportation stopped being provided. And if they're out of school for, let's just say, a month because there's no transportation, or more, 2 months, whatever it is, when they eventually do get back to school, you can request compensatory education services to account for the time that's missed. And what that is sort of a remedy where you're saying, school district, you violated our rights by not providing any educational services. As a result, over that period of time, my child regressed or failed to make the progress that was expected, and they need additional services to make up for that. So that could be more intensive tutoring outside of school, could be a change of placement, could be really anything that's necessary to allow the child to recoup what they lost. And a few other thoughts. A parent could arrange for private transportation and then submit for that to be reimbursed by the district. If you're going to do that, I would recommend sending a letter to the school, notifying them that you're arranging for private transportation because they were unable to provide it themselves, and request that they pay for it. That puts them on notice that you're doing this and gives you the opportunity later to attempt to be reimbursed, even if you need to file legal proceedings. You can do that, and you've provided the right notification to be able to be reimbursed.
And compensatory services, just to highlight, would include educational services as well as therapeutic services.
Yeah, absolutely. Whatever, use the IEP as a guide if you're in a place where you agree with what's in the IEP. If not, it's a little more complicated, but if you think your IEP is a good representation of your child's current abilities and needs, then you can use that as a guide to determine what services should be provided that were missed. And that could be anything from academic instruction, social work, physical therapy. And also we talk about doing a notice of provision of private transportation services. You could do the same thing for any of those related services or instruction. That's another way that you can ensure that your child gets services during that time. If you can get private services, either in the home or somewhere that you can get your kid to receive them, you could do that and seek reimbursement from the district.
Last question for you, and I know we are over time, so thank you for the added minutes, but if a school district doesn't offer an appropriate ESY program, there just isn't a great fit within the ESY services within the district, or there isn't one running or available, what are options for families to explore?
Well, again, similar answer to the previous one. If the school district isn't offering what your child needs, you can seek a private summer instructional program and notify them. Again, notify them in writing before you start the program. The standard for amount of notice is 10 school days before the program starts. You notify them in writing that one, they weren't providing an option that was appropriate, and two, you're starting this private program, and three, you want them to pay for it. That's what you need to include in your written notice, and again, provide that 10 school days before the program would start.
If we should say if ESY is written into the child's IEP.
If ESY is written into the IEP, or if there's a dispute about whether ESY is needed and you feel like it is, this is another place where outside clinical support is super important. So if you have a psychologist working with your child, or someone who can evaluate them and say, oh yeah, they're at big risk of regressing over the summer if they don't have services ongoing, they need ESY. If the school district disagrees, then, again, you may be in a place where you need dispute resolution, but you have that clinical support to back you up.
Great. And if I may, one more very good question came in that I don't think was covered. Do IEP services start as early as kindergarten? So can you actually just highlight the ages in which IEPs can start within districts?
Sure. So earlier than kindergarten. Yeah, there's early education, pre-K, I think ages 3 to 5 is when you can really start to receive services and evaluations significantly. Typically at that early age range, 3 to 5, your child will be potentially found eligible as having a developmental delay. But other disabilities can be diagnosed that early as well that could inform special education and related services. But yes, early on, you're still entitled to special ed and evaluations. Your school district, if your child's in Head Start or preschool at that age, then the school district has the obligation still that we talked about, the child find obligation to identify and evaluate them for special ed. But you should also, if you think that your child may need that, you should make them aware. And if you have, again, any outside clinical support, you should present that to your school district when you make a request that they evaluate.
Yes. And if your child is younger than age 3, knowing this can help prepare for that age 3, but then early intervention is available for children 0 to 3 years old. And so prior to that age 3, if there are evaluation and service needs, those will be provided through early intervention. Right. So if you have any follow-up questions, I will be following up with all attendees. Thank you so much for joining us today. I will follow up. So you have our contact information at the AARTS Center. If you have follow-up questions, happy to include Brad's information in there so you can reach out directly if there are follow-up questions or you would like a consultation with him. And then finally, I'll include these great resources in that email as well. Brad, thank you again for joining us today. Always a pleasure. And thank you, families, attendees, parents for joining us today. I will be posting this so you can rewatch parts of it if that is helpful to you. Thanks so much.
Thanks.